now going to travel to the 1830s. And let me preface this by saying that this is going to be a state-federal talk. We live in an era when the state governments are angry, many of them about what they perceive to be federal overreaching, requiring states to participate in the fulfillment of federal policy objectives, and this sort of thing. And a variety of lawsuits have resulted from this. This isn't a new phenomenon. And so we're going to return a little bit to some of the earliest expressions of this feeling of state discomfort or dissatisfaction with what the federal government has decided to do. And the focus is going to be on something called the nullification crisis. Now, this is something you may remember from your American history courses. You may remember the wild, sort of lion-maned figure of John C. Calhoun, Andrew Jackson, angry, threatening. You may remember the Civil War, which will eventually come, but not quite yet. In the 1830s, it's something different. And I want to talk a bit about the economic situation that gave rise to the nullification crisis, and then jump into the very difficult constitutional questions that resulted from the crisis, and eventually weren't resolved at this time. Political compromise was reached, but they were put front and center on the table, and eventually would contribute to the breakup, potential breakup of the Union, certainly the war. The Constitution, to get into the economics, gives the federal government in Article 1, Section 8, the power to lay imposts and duties, which is to say to collect tariffs when foreign states send goods to sell to the United States. And the federal Congress is also given the power to regulate commerce with foreign nations. So the regulation of this trade, and including the levying of tariffs, is something that the federal government is supposed to do. And everybody's on the same page about that at the Philadelphia Convention. The states aren't supposed to be involved in this except to the extent that they need to raise money to enforce their inspection laws, but that's not very much. So this is a federal thing, and for a while there was no problem with this. The tariffs were uniform. If you brought silk scarves into the port of Boston, you paid a tariff. Same tariff you'd pay if you brought them into the port of Charleston, South Carolina. But after a while, because there was so much money coming from tariffs, and in fact tariffs were the principal funding mechanism for the federal government for virtually the whole of the 19th century, for most of which there was no income tax. There was so much money coming in that folks in the federal government started realizing that they could start using this power of collecting tariffs as a means of implementing or achieving policy goals in the same way that the tax code is used today. And one of the goals that Congress decided it could realize was industrial self-sufficiency. We didn't produce much of anything in this country in the early half of the 19th century. We were good at rice. We did a lot with cotton. We could do cotton. And then there were various things that were coming out of New England, but we weren't a major exporting country. And we weren't even satisfying our own domestic needs. Part of the reason was that folks interested in establishing, say, a New England factory to make something had high startup costs and couldn't compete in either cost or quality of goods with Europeans who'd been producing these things for centuries, even with the transportation costs. So what New Englanders and folks in favor of economic development urged Congress to do was to raise the tariff on goods, imported goods, that folks in the United States were trying to produce, to give us, our domestic industries, a competitive advantage. And that would allow our industries to develop, and then we would be a healthier economy. And this was very popular in those parts of the country that were trying to develop these industries. Those parts didn't include South Carolina, which was a major importer of European goods. South Carolina was an agricultural state, a slave economy. and they were not happy when Congress started playing with the tariffs. They objected to it for policy reasons. They were the ones essentially paying for the development of New England industry. They didn't think that was fair. But they were unhappy for constitutional reasons too, because they didn't think that Congress had the power under the Constitution to use the tariff protectively, to use the tariff to encourage the development of industry in one part of the country. Article 1, Section 8 does say that Congress can impose duties, but it says it's to do so for the common welfare and for defense. And they didn't see this preferential treatment of New England industry as being intended to achieve either of those goals. So they started protesting. Now, the politics of the tariff, how it was set, became caught up with the politics of developing political parties. In 1828, Congress pushed through, to the surprise of many in Congress who intended this thing to be defeated, a tariff that raised the tariff rate so high on many imported goods that it was commonly referred to as the tariff of abominations. But it passed. And the president signed it, and South Carolina went crazy over this thing. Now, the incoming vice president in 1828 was a guy named John C. Calhoun from South Carolina. He was a nationalist at this point. He was a moderate, but he was dependent on a political base in South Carolina, which was increasingly angry about this use of the tariff power, the burden of which was falling disproportionately on them. So Calhoun secretly drafted something for publication called the Exposition and Protest, which advanced a new constitutional theory. And the theory was not entirely new, but in his formulation it was. The theory was that, okay, we all know Marbury versus Madison, the Supreme Court said that the courts get to decide what's constitutional. But Marbury doesn't say that only the courts get to decide what's constitutional. So who else can? Well, Calhoun's position was, and Madison to a certain extent, and Jefferson had agreed to this at an earlier time, that the states were the parties to the Constitution, so the states ought to retain the power to determine whether Congress was exercising its powers delegated to them by the states constitutionally. And if a state felt that the Congress had done something that was unconstitutional, that exceeded its delegated powers, then the state didn't have the power to invalidate it everywhere. That would be too much. But the state did have the power to invalidate it within the borders of that state. And this is the doctrine of nullification, that a state can nullify or declare null and void what it perceives to be an unconstitutional federal statute within the geographic limits of the state. He didn't take credit for this document. He was a vice president. But it became known that Calhoun had authored this, and for this reason and other reasons that we don't have time for, Andrew Jackson came to completely despise John C. Calhoun by the end of his term. And Calhoun would actually resign as vice president before Jackson's first term finished to engineer or to participate in his election to the Senate by the legislature of South Carolina to push the war against the tariff. And this theory of nullification that he had introduced in this document. 1832, Congress passes a new tariff to try and make things a little easier on the poor folks of South Carolina, but it doesn't go nearly far enough. And South Carolina decides, we've had it. So they convene in November of 1832. This is just before Andrew Jackson and his new vice president, Martin Van Buren, will swear their oath of office for the second term. That happens in March of 1833. In November, the people of South Carolina convene a convention that adopts something called the Nullification Ordinance. And it's an exercise of this claim power of nullification. It declares the tariffs of 1828 and 1832 null and void within the limits of South Carolina. It calls on the legislature to pass implementing legislation that will, among other things, require every state officer in South Carolina, which includes state judges, understand, except for legislators, to swear an oath of allegiance to the nullification doctrine, to the invalidation of these tariffs within the state, calling on making it a crime for South Carolina officials to aid in the collection of the federal tariff, providing criminal penalties, and attempting, in other words, to create an infrastructure for arresting the enforcement of the tariff within South Carolina, denying to anyone in South Carolina the power to take a case to the Supreme Court challenging the constitutionality of nullification of the ordinance or the doctrine or the implementing legislation. And eventually, when the governor and the legislature gets this, the governor requests a revision of the state militia laws so that just in case things don't go well, he can call up an army. And the final provision of the Nullification Ordinance says that if the federal government does try and stop South Carolina from invalidating, if the federal government does try aggressively to enforce the collection of the tariffs, then South Carolina's allegiance to the Union is dissolved. The deal is done, and South Carolina will become an independent country. This is in 1832, understand. This is 30 years about before the Civil War. Before South Carolina again does the same thing, and it's over the tariff. It's not expressly over the issue of slavery. Now, what's the federal reaction? What would you do? What would you do if you were Andrew Jackson, which may be a slightly different question? Well, Andrew Jackson, not surprisingly, this is Calhoun, this is South Carolina. He's a states' rightist, understand, but he isn't this kind of states' rightist. He believes that states should be able to do stuff under the 10th Amendment, their reserved powers, and the federal government has limited delegated powers, but he is not going to subscribe to the notion that states can individually invalidate federal statutes because a majority of people in the state think they're unconstitutional. That's the dissolution of the Union. Then the whole experiment is done, and Andrew Jackson's not going to preside over the dissolution of the Union. So he starts threatening everybody. And there's interesting correspondence about this in Washington as to whether he's serious. Thomas Hart Benton writes to a friend who says, does Jackson really mean he's going to hang everybody? Because this is what he's telling folks. And Benton says when Andrew Jackson, I'm paraphrasing, starts talking about hanging folks, it's time to start looking for a rope. Because he doesn't joke about stuff like that. And Jackson in December issues his own proclamation on the issue of nullification, in which he concludes by declaring that, in his view, this is treason. This is insurrection and treason that South Carolina is engaged in. Now, the legislative response is what starts to make this tricky for Jackson, because he has the power to take care that the laws be faithfully executed, and he's the commander-in-chief. So under one constitutional theory, he could simply call out the army and start shooting folks. But Jackson decides that he better get authorization for this first. This is an interesting phenomenon. It's applied domestically, but we see this in the international context a lot still, where the president uses the power as commander-in-chief to commit American forces to foreign actions without getting a declaration of war from Congress. Happens all the time. And there's even now occasional concern in the White House, well, should I get a statute authorizing me to do this? And that happens and has happened recently. The use of force resolution for the Iraq War, for instance, the president gets to do this. Well, Jackson's, I think, the first to actually take the approach that maybe he should get Congress to okay it and then get the authorization. He submits proposed statute that goes to the Senate Judiciary Committee and is called the Force Bill, which says South Carolina can't do this. You try and stop our people from collecting. It provides federal judicial counter remedies to the situation that the South Carolina legislature set up. And then says, and if the president deems it necessary to enforce these valid customs laws, the president can use the Army, Navy, and militia to go down to South Carolina and start whaling on folks It doesn't use that language exactly, but that's the idea. Now, it's that part that causes Jackson's former states' rights allies in much of the South to say, whoa, wait a minute. The Senate passes this, but when it gets to the House is like, well, you know, really? We're going to send an army in? Because this nullification thing, we may not agree with it, but the Constitution's kind of vague. And this is an early instance of this constitutional ambiguity. We tend sometimes to think, oh, well, the framers knew it, and then there's a fixed meaning, and why aren't we just applying it as it was written? But as early as 1830, people didn't really know how this was supposed to be resolved. The South Carolinians, you may think they were wrong, but they weren't stupid, and they had a position. And so a lot of people in the northern, the border southern states, northern states of the South and elsewhere, thought, well, I'm not sure we can go along with this force thing. And so Jackson ended up suffering a lot politically as a consequence of this because there is constitutional ambiguity. Now, the way this gets resolved eventually is through the efforts of the great compromiser Henry Clay. Clay, who's done these sorts of deals before, gets called in to help out. He's kind of old, getting older by this time. And Clay decides to talk to the South Carolinians, to talk to the Jackson folks, and talk to the New Englanders. And what he discovers is that South Carolina is really opposed to this tariff. They're not making this up. They don't think it should be immediately abolished. They understand that northern industry needs some protection, but let's gradually reduce it. So he gets introduced into the House a bill that does that, to the satisfaction of the South Carolinians. And the deal is that the Senate will approve that if the House approves the force bill, understanding that the President will never use the military to invade South Carolina because their needs are going to be met by the adoption of this new, they call it the compromise tariff of 1833. And the House says eventually okay, and the Senate says okay, and those things go through, and the crisis is resolved in the short term. One quick aside before I close on this. There's another issue that I'll talk about in a different lecture, a contemporaneous issue going on involving the Cherokee Indians in northwestern Georgia. This Worcester versus Georgia case is happening, and its enforcement is happening over the same summer. So there are two states' rights issues going on. Does Georgia have to follow the Supreme Court's order that's expected that it release 2 missionaries from jail? And the nullification crisis helps resolve that crisis too, in ways that I'll talk about a little bit later. But the point that I want to leave you with is this. It's this constitutional ambiguity problem. This is a big issue. Do states have the right to nullify unconstitutional statutes? Do states have the right to interpret constitutional statutes, and in doing so, are they doing anything more than expressing an opinion that has no meaning at law? Do states have the right to leave the Union if they no longer want to subscribe to the deal struck at Philadelphia in 1787? Who are the parties to the Constitution? The people of the states, or the states as legal entities? Does that matter? In what ways does that matter? These are all important. Oh, and then what's the scope of Congress's power under the tariff clause and the commerce clause? Is a protective tariff constitutional? All of these are live and very important constitutional issues in the 1830s, decided at a time when the Constitution isn't all that old. The fact that these issues were unsettled should, I think, help us understand the extent to which the document that we justly revere is in large measure an uncertain and ambiguous one. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.